pick up where we left off. Okay, so any questions so far? Okay, we'll proceed. All right, so one of the promises that we're making in this listing agreement is that we will file this information, this agreement, not this agreement per se, but we will file under the MLS rules 5 days after this listing agreement, within 5 days after this listing agreement begins. And so this is something that we need to keep in mind, that the moment this listing agreement is signed, the clock is ticking for us to get on the MLS. Now, the MLS requires us to have this information in the MLS within 4 days. So just keep that in mind.
And that, when you say days, that means holidays?
Calendar days, okay. Yes. Now, there is a lot of talk these days about the coming soon signs and things like that. If we have a listing agreement that is signed without making it clear that this agreement, this information would not be made available in the MLS, then it is assumed that it will. Unless you get into this next page here, and you see is paragraph 6B, okay? And where the seller actually gives you specific written instructions by checking this box not to file it within the MLS until, and then you have specific number of days. So let's say the seller says, I'm trying to get my house ready for showings, but it's going to take me an additional 10 days to complete it. My recommendation is, by all means, do take the listing agreement and then specify here, and I will have them even initial that part, and then to give you a reason why they don't want it to be listed as originally previously described within the 5-day period. There is also a situation in where a seller, and I do not understand why they would ask you to do this, will give you instructions not to list it, not to file it with a multiple listing service. And so there is a lot of heads up here to the sellers, that it will not be included in the database, and that other agents and brokers will not have an opportunity to know that this property is offered for sale. And again, the seller's property will not be included in the MLS to various real estate internet sites. So what is the point of having a house listed for sale if you're not going to put it on the MLS and let the rest of the world know? It's I do not understand that part, but you have the option there. The access to the property, this is an agreement with the seller, and the seller agrees that actually, if this house is going to be promoted for sale, that will give permission to other people to actually come into the property, and that there will be maybe the need to disclose security codes and having the key accessible by another party. Then there is the expectation, of course, that the property will be accessed through reasonable times, and the seller commits to authorizing brokers and their associates, inspectors, appraisers, contractors, and others to have access to the property during reasonable times, and that duplicate keys may be made available to facilitate the efficient showings of the property. Let me say something about this key box. This is something that I've done over the years. Perhaps during the past 12 years, we are somewhat in a bubble, and we understand that if we list properties in our general area, most likely we're going to be putting a lockbox on the front door, or in the immediacy or in the vicinity of the front door, sometimes front gate, sometimes a side door. Most of those lock boxes are going to be supra lock boxes, meaning accessible through either e-keys or your various fobs that are out there. Sometimes they're push button lock boxes. Over the years, I have made it a little more convenient for myself. When I take the listing agreement signed, I always request 2 copies of all keys. Because if you just ask a copy of a key, sometimes they may just give you the front door key, and you may not be aware of the fact that the rear door access to the yard may not be on the same key, or access to the garage door that may not be on the same key. So ask him to provide you with 2 copies of all keys. I make it a habit to put 1 key in the lockbox and the front door supra lockbox, and then I take a second key. I usually made an extra key for my office just to have, so that I don't have to inconvenience the sellers after asking them for 2 keys for every lock in the house. And I put a secondary key on a push button lockbox on the side of the house, usually on the faucet on the side where the water hose typically is involved. Because what happens is, in the process of doing this, sometimes you contract with, if not you personally, the buyer's agent will contract with an inspector that may not have access to a supra lockbox, or an appraisal appraiser may come by and want to do an appraisal on the property, and they will need access. And short of actually taking time out of your schedule to go and open the lockbox for them, you may give them access to the code on the push button lockbox on the side of the house. That has saved me invaluable time, particularly when the properties may not be in the general area. You know, I have had a listing in Baytown, and that's a 50-minute drive one way, and some of the real estate agents in that area do not have supra key boxes, and so consider doing that. Now, you purchase them through either HAR, there is a number of third-party vendors. You can buy them even branded with Remax logos. If you go to Main Street Marketing tab, they will show you all the preferred vendors.
You can even buy them at Home Depot.
Yes, you can.
They're everywhere.
Yeah. One thing to note here is that when there are tenants occupying the property, it's imperative that you obtain permission from the tenant in writing, and there is a form to do that, to give you access to the property. And so that person or those people would actually be the ones that need to be contacted through the MLS to make appointments when an appointment is made. Then there is a liability clause. This liability clause actually says that when authorizing access to the property, the broker or their brokers, their associates, any key box provider, or any scheduling company are now responsible for personal injury or property loss to the seller. Along with that, you should advise the seller to please be aware of the fact that although we're not responsible for security, we are advising him to put away all valuables, prescription medications, firearms, or any other items that could endanger anyone who is visiting the property. And you know how curious sometimes children are, and so never underestimate their ability to get into places that they shouldn't, even though as professional real estate agents, we should always keep an eye on anyone visiting the property and ask the adults to please take charge of their children. Yes?
I wanted to clarify, the agent, if we're showing a property, the agent contacts the tenant, or the
No.
showing service contacts them?
The showing service will contact the tenant.
Okay.
Yeah, they will in fact become the contact people when an appointment is being made. Yes. But you have to have the written authorization from the tenant that someone will have access to that property and a key, and that appointments will be made through centralized showing service to enter the property. And obviously, the seller assumes all risks, and except for a loss caused by the broker, seller will indemnify and hold the broker harmless. This is a situation in where sometimes brokers in the process of showing the property may do things that you will not expect. And I can think of a couple of situations in where unintentionally brokers will give access to prospects, buyers to the property, and unknown to the showing agent, they may do things that were simply curiosity on the buyer's part. I can think of one situation in where a buyer actually turned on the switch for an electronic fireplace, and the agent, in shutting down the lights and everything else, noticed, turned it off, went on to turn off the rest of the lights, and there was a child in the premises that actually was, I think, trying to help the agent turn off the lights, and he turned on again the fireplace switch. The agent locked up the property, they left. This was around 4 o'clock in the afternoon, and around 11 o'clock at night, the listing agent shows up to the property, and the fireplace was on, and it was a great situation, was a grave situation, because if a fireplace had been allowed to remain on for a few more hours, probably it would have been a fire hazard. So you have to be very cognitive of what's going on. You have to make sure that you learn to prevent as many things as possible. The fireplaces sometimes have a control in where the gas will be turned off, and you may suggest that that be done, particularly in the summertime. There is no reason to have access to the fireplace, and so you can turn the safety gas valve off for the fireplace and prevent damage. Also, the stove, but that's a little easier to see when you're showing. So make sure that all the lights are off and all the doors are locked, and you will reduce risk. This is the part in where you actually agree to share with other brokers the commission that it was previously listed, and you can actually put a percentage. You can put actually an amount. Typically, this is what you will see is 3% when the buyer represents, when the buyer's agent represents the buyers. And then sub-agents, typically you have a choice to compensate them or non-compensate them. Sub-agents are basically real estate agents, licensed real estate agents that may or may not have, actually typically will not have a buyer's representation agreement. So many of agents in the Houston Association of Realtors do not compensate buyer's agents. The truth be told, very few agents actually verify whether or not the buyer's agent has buyer's representation agreements signed by their buyers. So this item number 2 in both A and B, it's frequently not enforced. If push came to shove, there could be an agent out there showing properties without a buyer's representation agreement who runs the risk of not being compensated. If you're showing properties, be sure that you look the MLS and see if the sub-agent is being compensated. This should be sufficient reason for you to try to obtain a buyer's rep agreement. Intermediary is when you ask the seller to basically allow your broker to actually represent, bring buyers, agents to show their property. In other words, in most cases, item number 9 will be checked, yes, and we allow intermediary. Who is the intermediary in a relationship and where, let's say, Remax, the Woodlands and Spring, is representing the seller? What will cause an intermediary relationship?
Another Remax agent brings the buyer.
Remax, the Woodlands and Spring agent from any of our 3 offices. Yes. And so that situation, I'm the broker, I'm the intermediary, and then we will actually have with appointments or without appointments. Guess what the difference is?
If you don't have appointments, then you can't advise your client.
That's right. Give advice or opinion, right? So if I have a listing and I get a buyer to call me off a sign and I show them the property and they want to engage, I have 2 options, right? I either appoint agents or I'm limited from actually giving advice or opinion. That's a big difference. I'm sorry?
Who makes that choice, you or?
Well, you as a real estate agent, if you're the listing agent, you can make that choice.
And this office doesn't have a policy or an opinion on
Well, we do have a policy that if you are going to be in the middle of a transaction without appointments, that you cannot give advice or opinion.
Okay, but
Yeah, and that's part of the intermediary form. And so they can also check no intermediary status, meaning that they're going to lose an opportunity for have many Remax agents to represent or to bring buyers by. Yes, Frank? Oh, I thought you had a question. Sorry. You were just reaching for the camera. Sorry. That's okay. No. All right. Okay, so confidential information during this listing or after it ends, the broker may not knowingly disclose information obtained in confidence from the seller except as authorized by the seller or required by law. The broker may not disclose to the seller any confidential information regarding any other person broker represents or previously represented except as required by law. In other words, there's information that may be shared with you as a listing agent that you can actually keep in the back of your mind, but because of your fiduciary responsibility to your client, that means that that information remains with you. And it could be a multitude of reasons or situations that the homeowner may share. Divorce, family members' laws, I mean, a number of financial situations may exist that you should not disclose. And that means should not disclose even after the listing has expired or has been terminated. Okay, so here's the broker's authority. When it says broker, that means more likely you, because you're representing the brokerage at that point in time. So you will use all reasonable efforts and act diligently to market the property for sale, procure a buyer, and negotiate the sale of the property. The broker is authorized to display this listing on the internet without limitation unless one of the following is checked. And so typically these days we don't have any sellers that do not want their property not displayed on the internet. It was an issue in the beginning, but no longer. Sometimes the seller does not want the property to be displayed, the address displayed. What is the point? You're showing the property to the world, literally. So not showing the address. If you do not show the address on the property, guess where all the calls are going to go to? It's going to go to the listing agent. It's going to be a great inconvenience.
I did have a listing client who chose not to list their home for sale, and one of the reasons was they were nervous about photos of their property being on the internet, thinking that people were going to come and steal their stuff.
Yeah,
Would it be possible to check number 2 and for me to say to them, the general public will not know the address of the property, but only professional real estate agents?
I can assure you that you can demonstrate to your clients that even if you do not show the property on the internet, if you just Google the address of the property, other prior listings will surface that will actually show everything about the property. You can do that, but I'm telling you, you can obtain more information that any seller will anticipate. I mean, all the information that is available through the appraisal district and through Google and Google satellites and what is it, Google Street or Street View. Photography exists on most properties that you can actually see prior listings if you want to. If you go into Temple these days or Fusion and look at the new tax access, the records, you would actually see what the previous listing numbers were, who the agents were, and actually have access to that information through it.
But if we check number 2,
If you check number 2,
but they don't want the address displayed,
yes.
the agents will still have access to the address on the MLS, but I presume it would be blocked from a public view of that listing on HAR.
And frankly, I do not know how to do that.
Okay.
I have,
With a short sale, yes, if you put number 2, it will show it to the listing, to the agents, but not to the public, and they
Okay.
will have to do a form with Tempo, that the seller requested that.
Yes. So that might have helped me get that listing,
yeah,
if I could have, even though you're right, that information's
Yeah.
out there, just to give them that little bit of assurance.
Yeah.
yeah, I,
More than one, a yard sign either.
Yeah.
It's a short sale, so that's why.
right. I can understand those situations, but I can assure you that be careful on what you promise. At least do the research on the internet when you pull that address, because you're likely to come up with more information. And if that information is available out there, you may get the blame for it. And you may have to explain why, if I check that area and where my address will not be displayed, my address still showing on there, not on the listing per se, but on a prior sale. So make sure that you set the correct expectations there.
I do have a question. I've been looking, or when I look at some of the homes, like in the higher price bracket, they have secret rooms or like safe rooms.
Right.
Like, I don't know, like, I'm wondering, why do they put that for the public to see? Because what's the point of
Yeah.
a safe room?
Yeah, I never actually get into, if there are hidden features in the home that are safety related. I typically don't get into that.
Like, don't
Um,
take pictures of it? If
yeah,
it's
no,
not showing,
that's
like,
not a good
you
idea.
show them that?
Yeah, that's not a good idea. Yeah, but those are best practices. Yeah, those are best practices. Yeah, just use your common sense when it comes to it. Don't advertise, but certainly do not take photos of how to access it. The broker, obviously, most situation these days, conventional VA, FHA, cash, and other available programs to buyers is in the best interest of the seller. Ask the seller if they have any issues offering this home to pre-approved buyers that are purchasing through VA or FHA. Typically, they're going to ask you what is the difference. Typically, there is no difference. However, you may want to demonstrate, maybe give them a net sheet of what it would amount to in terms of dollars and cents to sell to a conventional buyer versus an FHA or VA buyer. Typically these days, there isn't any additional costs. I'm going to move quickly here. I got 10 minutes. Okay, so these are additional authorities that the seller is granting you. Put in a sign, put in the property, in the various vehicles. We make a big deal that their ability to sell their home is highly correlated to the number of sites that this information may be available on. You will know from your experience that if we list a property on the MLS, almost automatically, most of the main websites, whether it's Remax.com, Realtor.com, Trulia, Zillow, Redfin, and others, will actually have that information. So how does that happen? That happens as a result of HAR syndicating the information to the other sites. It is really interesting how that works, because we pay the HAR to make this information available to all of our agents. HAR charges other firms for the syndication of this property. And what's really ironic to me is that we as real estate agents pay those third parties and HAR in order to have a relationship with them. So it's mind-boggling how, we end up paying our association to syndicate, to list our properties. HAR makes money on the syndication, and then the other firms make money from us on top of what we already pay.
Sometimes the information is not correct.
Sometimes it's not. That is absolutely correct. Sometimes the information is either late to be displayed, or they grab information from prior listings, and it's up to you to keep an eye on those things. So these are representations that the property is theirs, that the property is, they have ownership, and that they is now bound by other listing agreements. By the way, do yourself a favor, before you actually go take a listing, run the property on the MLS and find its history. Find out that it's not currently listed first, because if it was listed and they want to switch agents, it is extremely important that the other agent is in agreement. Because if a seller is still under a prior listing agreement, you may have problems obtaining the listing. The prior broker may refuse to do that. So have a conversation with the sellers about the details. Be sure that you do your due diligence to take the necessary precautions regarding pools, fences, whatever. Find out also who else may have access to the property other than you. You need to find that out in order to have them aware of the fact that this property is on the market. The last thing we need is for a distant owner to have given keys to someone else and to have a real estate agent show up to the property only to find a big surprise that somebody else is actually staying in the property and that they're not privy to being contacted by the centralized showing service. It is in your best interest to check with the title companies to see if there are outstanding liens, mortgages, or equity loans, home improvement loans, if there are any lawsuits pending or taxes, demands from entities before you list the property. It will help you in the end.
Is that what we call by opening title? Is that what you?
Yes,
Okay.
yes,
So just check with your preferred title company. Yeah.
correct. Sometimes there is a requirement from an employer, there are benefits to them, and if you actually do not get them to acknowledge, you may find out there is a relocation company involved in the process that you were not aware, and at the end of the day, you may have to pay at least 1/3 of your commission. So it is good to know and get them to acknowledge that this is not part of any benefit provided by the homeowner's employers. Then there are additional seller's promises, being cooperative, making the property available, not to lease it during the period of the agreement unless you have a separate listing agreement for lease, maintain all equipment, pools, and work in order, give you the necessary seller's disclosures in a timely manner, and then there are limitations of liability to the brokerage. It talks about where the broker or the brokerage is not responsible for, particularly during periods of harsh weather. In some areas, acts of vandalism, stolen air conditioning units, things like that come to mind. And making sure that the property is in compliance with any deed restrictions, that somebody's going to be mowing the grass if they're not going to be present, and otherwise maintaining the house in working order.
Can you open title before, like if you have, I mean, will they open title for you before you take the listing?
Yeah, they do. Most title companies will collaborate with you in exchange for maybe bringing, you have no control on that. Sometimes the buyer's agent will want to use a different title company, and per RESPA, you cannot dictate what title company is going to be used. They're negotiable. I got a note to myself here on my special provisions that this we delete, my assistant would delete before actually printing it or sending it out. It's a heads up, basically, that I have to have supplemental seller's disclosures. It's mandated by our office. Then he talks about defaults and mediation and attorney's fees and all that good stuff that you should be very much aware as far as this is the part that typically escapes. You should at least be thoroughly familiar with the language in this form, and if necessary, I try to explain it to my sellers ahead of time. I summarize. I don't read the form like I'm doing here. I typically make this part of my pre-listing package so that they have an opportunity to review. So when I come to sign, they already have had instructions to please review what we're about to sign. And then if there are any questions relating to this, we will go through when I come to pick up, the signed documents. These are other documents that may form part of the listing agreement, and obviously the seller's disclosures will be part of that. Remember, the seller's disclosures notice is part of the listing agreement, but it's not part of the contract. Okay? Keep that in mind. Seller's disclosures do not form part of your contract. So when you send the information to the title company, you do not have to send the seller's disclosures in. As long as you have acknowledgement from the sellers, from the buyers, that's all you need. Okay? Because you don't want the seller's disclosures to become part of contentious, disagreements at the title company.
So we do check the box or no?
You do check the box as far as the listing agreement, the addenda, and other documents that are part of this listing.
And
But-
and then we would write in at the bottom the supplemental seller's disclosure under O?
Yes, you may.
Okay.
Yes,
And seller's exclusion list?
Yes.
Would that be there also?
that could be any form that is actually part of it.
Okay.
Okay, so this is more legalese, agreement of the parties. Additional notices about compensation. Remember, prior to 1978, we have to include the lead-based paint disclosure. And remember that you are not an attorney for the most part. Any attorneys here? Most of our agents are not attorneys. So, and you do not need an attorney for this as well, but it is good to have, give them notice that you're not, and that they have the right to consult with an attorney before signing. Usually we say that very quickly.
But you know, one
Yeah.
thing, Raul, if you've completed your cover sheet in zip forms,
Yes,
and you get to this page, you may wonder why the seller's name and the broker's name has not auto-populated. But at the end of each active field, if you just hover over it, there will be a drop-down arrow, and then you'll be able to select the information that you put on the cover sheet.
Thank
So
you.
It is there, it's just you gotta hunt a level down for it.
thank you. All right, so any questions regarding this form? We're at 12 o'clock. I don't want to keep you from,
That's miraculous, Raul.
yeah, really, literally.